Hello everyone, welcome back to LearnCity and welcome back to Human Resources class. In today's class, we'll continue from our Module 1, which on that day we'll be talking about the legal considerations and risks associated with employee handbooks. Employee handbooks are a vital component of any organization's human resources strategy. It is important to be aware of the legal considerations and risks associated with creating and implementing an employee handbook. Failure to comply with legal requirements can lead to legal disputes, damages to reputations, and financial penalties. Here are some legal considerations and risks associated with the employee handbook. Number one, employment laws. Employee handbooks must comply with the federal, state, and local employment laws. These laws include but are not limited to anti-discrimination laws, wage and hour laws, and family and medical leave laws. Failure to comply with these laws can result in legal disputes and financial penalties. Number two is at-will employment. Employee handbooks often include language stating that employment is at will, which means that either the employer or employee can terminate the employment relationship at any time for any reason. However, some state laws limit the use of at-will employment language. Employers must ensure that the at-will language complies with applicable state laws. Number three, contractual obligations. Some employee handbook contains language that creates contractual obligations between the employer and employee. Employers must be careful when including language that creates contractual obligations, as it can limit the ability to terminate employees or change terms and conditions of employment. Number four, privacy laws. Employee handbook may contain policies related to employee privacy, such as emails and internet use policies. Employers must ensure that these policies comply with applicable privacy laws, such as the Electronic Communication Privacy Act. Number five, harassment and discrimination policies. Employee handbooks should include policies related to harassment and discrimination in the workplace. Employers must ensure that these policies are compliant with the federal, state, and local laws, such as Title VII of the Civil Rights Act and the Americans with Disabilities Act. Number six, disclaimer language. Employers often include disclaimer language in their employee handbook to limit their liabilities for certain policies and practices. However, this language must be carefully crafted to ensure that it is legally enforceable. In summary, legal considerations and risks associated with employees' handbook include the compliance with employment laws, limitations on at-will employment languages, contractual obligations, privacy laws, harassment and discrimination policies, and disclaimer languages. Employers must carefully consider these legal considerations to ensure that their employee handbook are compliant with applicable laws. The risks associated with non-compliance.